Hello, and welcome back to Business Law Online. These next couple of lectures, we're going to be discussing intellectual property. Now, intellectual property is an important subject, I believe, in business. So much of the value of a company is really wrapped up in the type of intellectual property rights it has, whether it be a trademark, a copyright, a patent, a trade secret, whatever the case may be. Intellectual property serves a huge role in assessing the value of any company. So what exactly is intellectual property? Well, we covered real property, you know, land and buildings and things that grow on it and the like. Intellectual property is a form of intangible property. It's basically a right. It's basically the exclusive right to use an idea, an invention, some kind of creative or artistic endeavor, or a trademark. It's the exclusive right to use one of those things for the benefit of your company. And there's a lot of value in that. We're going to be going over patents first, then copyrights, then trademarks, and kind of related to that is trade dress, and also trade secrets. So those are the four areas that we will be covering. All right, so patents. Let's start first with patents. Well, what do patents protect? For the most part, patents protect inventions, scientific inventions. Another way of expressing that is they protect the application of scientific principles. They do not protect the scientific principles themselves, only what comes from the scientific principles. So, for instance, perhaps one of the most famous scientific principles of all time is Albert Einstein's theory, E equals mc squared. Now, that principle, that formula, that is not patentable. But what is patentable would have been the subsequent nuclear technology that resulted from it. So that could be patented, but not the principle itself. And that's basically what patents covered. Now, patent law is strictly federal law. We're going to talk about international law as well a little bit, but patent law is strictly federal law. There are no state patent laws to speak of. So it's covered entirely by the Federal Patent Statute of 1952 and has been amended over time. But that is basically the governing statute for patent law. Now, what can be patented? Well, it's an invention, but more than that, if you're gonna file for a patent, the thing that you file for has got to be novel. In other words, it needs to be new. It's got to be non-obvious. In other words, it's something that is a significant step above what already exists. And three, it's got to be useful or utilitarian. It has to have some kind of utility or usefulness. Now, with that in mind, we're going to talk about utility patents first. And utility patents cover things that are novel, non-obvious, and useful. And they would be, for instance, things like machines. A machine could be patented. There are lots of examples of complex to simple machines all being patented. Zippers have been patented. Believe it or not, there are all kinds of different zippers, each with their own patent. Very simple machine. Sewing machines, computers, all of that has been patented. So machines can be patented and their component parts. Processes can be patented. So for instance, pharmaceutical companies, drug companies, they realize that for a lot of patients, swallowing drugs could be difficult. So they tried to make it easier by coating the drug with a thin coating that would make the pill a little bit, for lack of a better word, slippery. So it would slide down your throat easier. Well, that process of coating the pill, that can be patented. For those of you interested in fashion, Francesco Ricci, the Italian designer. He patented the process for stone washing denim. The process by which we kind of make denim look more distressed than it actually is. There was a patent for that. It actually, I believe, expired in 2008, but there was, in fact, a patent for that process. Another thing that can be patented, another type of utility patent, the composition of matter. For instance, pharmaceuticals, drugs, putting together things like that, the composition of matter. In terms of fabrics, there was a patent on Gore-Tex, which was kind of the predecessor for the heat technology that Uniqlo now sells. But Gore-Tex, the idea was the same. Help keep you, it's very lightweight, helps keep you warm. So that was also patented, a type of composition of matter. Improvements to machines, processes, or the composition of matter. They can all be patented. Asexually reproduced plants, in other words, plants that don't have flowers, they can be patented as well. And finally, in terms of utility patents, living material invented by persons. It sounds kind of like Frankenstein, but basically it's an example of that would be, for instance, oleophilic bacteria. Now, oleophilic bacteria, it exists in nature. It's an oil-eating bacteria, but there have been strains invented by people. And as a matter of fact, there was some brief discussion after the BP Gulf oil spill that maybe they would dump this oleophilic bacteria at the spill site to help clean up some of the petroleum, some of the oil that had spilled out. So those are all things that can be patented. Those are all utility patents. Now, this is important. Utility patents only last 20 years, and they cannot be renewed. So once the 20 years is up, anyone can use them. So just keep that in mind. Now, there is another type of patent, and it's referred to as a design patent. Internationally, they're referred to as industrial design patents, and they're also known as picture patents. And based on this last description of them, you can kind of get a sense of what they protect. They protect the look of something. So, for instance, a belt buckle. That could be the subject of a design patent. Now, for a design patent, you have to establish, well, one, it's novel or new, two, non-obvious, but instead of useful, instead of utilitarian, you have to establish it's ornamental. In other words, it's strictly for the looks. That's the only thing that you're patenting. So, for instance, if you would take the Apple iPad, the pad was really, it's really a brand new product category, right? It's bigger than a smartphone. It can do more than a smartphone, but it's not quite as big as a laptop. You know, as a matter of fact, that product category is referred to as a tablet. And Apple actually got this idea really from ancient society, when you had scribes who would follow around the king, and they would have a tablet in hand, a clay tablet. And if the king decided to issue a new law, the scribe would dutifully write that law in a tablet and then disseminate it, throughout the kingdom. That's really where they got their idea. So let's think about the iPad for a moment. Well, an iPad is really just a computer. And at the end of the day, what is a computer? Whether it's a desktop or an iPad, you have a hard drive, memory, and a screen. That's really what a computer is at the end of the day. So there can be utility patents on the hard drive, the screen, and the memory, those individual components for the iPad, as well as all of them together, all the component parts are working together. There can also be a design patent on the look of the pad, because it is a new product category. It is different. Just that shape of the pad. It's like in the shape of, well, a tablet. So there can be a design patent on that. So design patents and utility patents, they can work hand in hand. Now, design patents only last 14 years, and likewise, they are not renewable. So that's just something to keep in mind. All right, so how do you go about getting a patent? Well, it's all federal law, and it's governed, as I mentioned before, by the Federal Patent Statute of 1952. Um, Basically, you have to fill out an application. You have to fill out an application and submit it to the U.S. Patent and Trademark Office, which is actually a fairly well-run federal government agency in terms of what they do. Before you do that, before you prepare the patent application, well, first off, keep in mind a patent application can be very expensive. The whole process from beginning to end, it could easily be $20,000 and up, easily. So before you make that kind of investment, what you may want to do is, there are companies that do this, is search the records at the U.S. Patent and Trademark Office to see if anyone has invented what you seek to patent. Because if they have filed for a patent, you wouldn't be able to file your patent, or they'd be able to claim that you're infringing upon their patent and sue you for patent infringement, which is not a good thing. So the first thing you should do is search the U.S. Patent and Trademark Office records for similar patents. This is referred to as searching for, quote, prior art. And I don't mean art strictly in a creative sense, I mean in the sense of anyone's work. You're going to search the prior art, see if there's anything that looks similar. You fill out the patent application, and you have to establish that what you seek to patent is in fact new, okay? It's non-obvious, and it's useful. So you have to establish those criteria. And you do that in large part by alleging your claims. You have to include your claims. The claims, that's what, you put your claims in the patent application, and that's what makes it new, obvious, and useful. You include schematics of whatever it is that you're seeking to patent from every possible angle. So you could see that potentially that could be quite time-consuming. I mean, if you have a complex machine, the schematics should be dozens, hundreds of pages. It could be quite complex. So you submit the patent, assuming there's no similar prior art, you submit the patent application. Now, if you wanted to, if you pay an extra fee, you could file a provisional patent application. And what that does is it gives you the option of putting patent pending on your product. What does it mean to say patent pending? Well, what it means is it's really a warning to would-be infringers. If you're going to copy my invention, keep in mind I have filed for a patent, and the moment it is granted, the moment the U.S. Patent and Trademark Office grants my patent application, I'm going to sue for patent infringement. Patent protection is retroactive to the date of application. And if you want patent protection, by the way, you really have to file with the U.S. Patent and Trademark Office. That's really the way to get it. As a matter of fact, I mean, just as a good practice, I mean, you can release your invention to the public before you get patent protection, but you're skating on thin ice. Soon thereafter, soon after you release it, if you're inclined to do that, which I wouldn't recommend, you should file for a patent application, because you don't want someone seeing your idea, seeing your invention, and then what? Filing their own patent application. So although you can release it, you don't want to get into that kind of sticky situation of someone else taking it and filing it. So you file the claims. Now the patents, provided and you put patent you could put, if you pay the extra fee, provisional patent application, you can put patent pending. And if the patent is granted, you will be able to put on your item patent number whatever. And you should. Why? Because it makes it easier to prove patent infringement. Specifically, that the other side knew there was a patent in effect, but they disregarded it. It's not innocent patent infringement. It's guilty patent infringement. It wasn't a mistake that they copied your design. They knew what they were doing. They saw that there was a patent in effect. It also makes it easier to collect statutory damages. Or really that's the only way you can collect statutory damages. So that's extra damages on top of your actual damages. So you can collect statutory damages in a patent infringement lawsuit. You can file your patent internationally. What that means is that you work through the Patent Cooperation Treaty. You could do this through the U.S. Patent and Trademark Office. What they will do is they will take your patent application and they will file it basically with all the other countries that have signed the Patent Cooperation Treaty. Now, what the Patent Cooperation Treaty did, it didn't regularize the patent approval process. It just streamlined the patent application process. So through the Patent Cooperation Treaty, your patent application is filed with all the signatory countries. And it's great. It's great. But it doesn't mean necessarily that those countries are going to approve your patent application. As a matter of fact, they may not. Different countries have different requirements. So as a practice point of view, it would behoove you, if you do want to file for patent protection in another country, yes, file in the United States, work through the Patent Cooperation Treaty, but then get local counsel in the country you are seeking to do business in, so that they can help get that patent approved in that country. All right, that's for utility patents. The same is pretty much true with respect to design patents. You have to file a patent application, and you have to submit, schematics and claims. But instead of having to prove that it's useful or utilitarian, you have to prove that it's strictly ornamental or mostly ornamental. So that's the allegation there. Now, a big difference between design patents and utility patents: you cannot file a provisional patent application for a design patent. You cannot put patent pending on something that you are seeking a design patent on. So that's just something to keep in mind. Again, remember, design patents only last 14 years. And again, once the patent is granted, the design patent, you could put design patent number, whatever it is, on the goods, and that's really all you need to do. All right, so what does a patent give its holder? Well, it gives them the exclusive right to exploit their invention. So that's really what we had mentioned before. Intellectual property rights basically give you a monopoly over something. All right, copyrights. Now, copyrights they protect copyrights. Whereas patents protect invention, the application of scientific principles, and they can protect designs, copyrights protect artistic and creative elements of something. Copyright is governed by federal law and is currently governed by the Copyright Revision Act of 1976. It establishes the requirements for obtaining copyright protection. Now, the thing about obtaining a copyright, copyrights do not protect ideas. They protect the creative and artistic expression of ideas. So, and the more creative and artistic something is, the more protection it has. So a great case, a fantastic case to demonstrate this, Tarzan versus Conan the Barbarian. the people who, the company that owned the copyright to Tarzan, the jungle hero, they sued the copyright holders of Conan the Barbarian, saying that Conan the Barbarian infringed upon Tarzan's copyright. Um, and the court there said, no, it didn't. Why? Because what is Tarzan? Tarzan is really just a muscle-bound superhero in a loincloth. And this is almost the court verbatim. Is that closer to an idea or an expression of an idea? It really is an idea. Muscle-bound superhero. There's nothing really that artistic or creative about it yet. He speaks in broken English. It's a very simple character. There's not a whole lot of artistic and creative expression there. As a result, not a whole lot of copyright protection there. So what is Conan? Conan is really almost the same thing. A muscle-bound superhero. But that's closer to being an idea than the artistic expression of an idea or the creative expression of an idea. So the more creative something is, the more protection. For instance, Harry Potter, the character Harry Potter, very well developed character, would certainly have a lot of copyright protection. Copyright protection, it only extends to things that are tangible. So if I were to, for instance, recite in class, in one of my traditional classrooms, some kind of slam poetry, would I have a copyright over that poem? No, I wouldn't. I wouldn't be able to apply for copyright protection or seek copyright protection until I wrote that poem down on a piece of paper. It's got to be tangible. It can't just be an oral history of some kind, oral story or anything like that. For copyright protection to apply, it's got to be original. But there's a little twist there. It's got to be original as to the artist, not necessarily completely original as to the world. So, for instance, with music infringement, written songs, they certainly apply for or are eligible for copyright protection. And the fact of the matter is, there are only so many notes and so many chords, and there are only so many combinations of notes and chords that you can come up with. So, is it really that unreasonable that a singer-songwriter in Southern California and a singer-songwriter in France would come up with a song two different songs that kind of sound the same? Well, not really. And that's fine as long as neither one of the artists, of the singer-songwriters, had any contact with each other. It's just fine. It's just fine. So it's got to be original as to the artist. That was the case. There was an interesting case involving the Bee Gees, particularly Barry Gibb. In the soundtrack to Saturday Night Fever, there was a song, How Deep Is Your Love? And a singer-songwriter in Southern California said, hey, that song is similar to a song that I wrote, very similar to the song that I wrote. And he sued, that singer-songwriter sued the Bee Gees and Barry Gibb for copyright infringement. Barry Gibb's defense was basically, I didn't infringe upon his copyright. As a matter of fact, the work is completely original to me. And much of the case was spent trying to establish where Barry Gibb or the Gibbs brothers or their agents or associates were at the time that the plaintiff was writing this song and performing it in Southern California. So it's got to be original. Just a brief note, clothing, generally speaking, is not eligible for copyright protection. Why? Because clothing is primarily utilitarian. It's primarily useful. The point of clothing is what? To protect us, to protect people from the elements, keep us warm, keep us dry, keep us safe from the elements. But that doesn't mean that individual elements of clothing cannot be copyrighted. So, for instance, suppose you took a photograph and you put it on a t-shirt. Well, although the t-shirt is not copyrightable, that photograph is. Also designs and patterns and fabrics. they can also be copyrighted. What else can be copyrighted? Well, books, magazines, television broadcasts, movies, radio broadcasts, anything that is artistic or creative, paintings, and the like. All right. Now, copyright protection is interesting. Whereas with patents, you have to file for patent protection for it to apply. With copyrights, filing is voluntary. You do not necessarily have to file with the U.S. Copyright Office for copyright protection to begin. Copyright protection begins the moment the work is complete in a tangible form. Not when you register with the U.S. Copyright Office. And you don't even have to register. You could create a poor man's copyright. If you wrote a song, you can have 2 copies of the song. 1 copy, what do? You mail it to yourself. And if anyone were to ever allege that you violated their copyright, or you're alleging they violated your copyright, you would have that as evidence, and you can open it up in court to show, yes, I created this song on this date, and look, the U.S. Postal Service, date stamped it on this date. But copyright protection, unlike patent protection, is relatively inexpensive to apply for. It's only maybe, if you do it online, $500 plus some extra fees. So it's cheap. It is a cheap way of getting protection. And you could do it online, as I mentioned before. How long does copyright protection begin? Well, I'm sure all of you know who Sonny Bono is. Sonny Bono, the husband of Cher, the ex-husband of Cher. Well, after he was done with his music career and his television career, Sonny Bono opened up a restaurant, and in Palm Springs, California, a very nice neighborhood, very nice community, very wealthy community. And he didn't like the way that he was being treated, so he decided to get involved in politics. I'm telling you all this for a reason. Hopefully you'll never forget how long copyright protection lasts because of this story, because it's important to know. So he ran for mayor of Palm Springs, California, and he won. He was very popular, and he ran, and he won. But he had bigger ambitions. He actually wanted to be a U.S. Senator from California. So he ran in the Republican primary to be the Republican nominee for U.S. Senate in California. He lost. But he did very well in Palm Springs and the surrounding areas. He was very popular. He was a very popular figure in that area. So he ran for Congress in that area, and he won. And he won. And he went off to Congress, and he served for a long time. Well, actually not that long, until his death, his premature death due to a ski accident. But he one of the pieces of legislation that he sponsored was the Sonny Bono Copyright Extension Act of 1998. And what this did is it extended the term of a copyright. And it depends. Did the person come up with this artistic or creative piece for themselves, or in the context of their employment? If it was an individual who did it for themselves, the copyright lasts for that individual's life plus 70 years. If they did it within the context of employment, they did it in essence for their boss. Okay. The copyright lasts either 120 years from the date of creation or 95 years from when it was first published, whichever expires first. So it's a really long time in any event. Certainly, if most of you are in your 20s, if you were to write a song, that copyright would be good for the rest of your life. Hopefully you live for a really long time, 80s or 90s, so that's 60, 70 years. Plus it's another 70 years thereafter. So copyright protection lasts a really long time. But once it's up, that's it. It's over. The work falls into the, quote, public domain. But that doesn't mean that you can just copy the work. Now, for instance, the works of the great composers, Mozart, Beethoven, and the like, All of those works are in the public domain. The copyrights for those expired a long time ago. And yes, they did have copyrights. Mozart and Beethoven, all those great composers. That's how they made their money. So for instance, you can play Beethoven's Fifth Symphony. You can play it. But does that mean you can use the New York Philharmonic's version of Beethoven's Fifth Symphony for your commercial? No. Why? Because the New York Philharmonic will have a copyright over its version of Beethoven's Fifth. So you can play Beethoven's Fifth all you want, but you don't have to pay Beethoven. But in terms of using other musicians' recordings of Beethoven's Fifth, well, they would have a copyright over that. The same holds true, for instance, with paintings, right? The Mona Lisa. The Mona Lisa is in the public domain. Does that mean you can use any photograph of the Mona Lisa? No. No, because the photographer would have a copyright over that photograph. So that's just something that you should keep in mind. Now, the key, again, I don't want you using these terms interchangeably. Patents and copyrights are very different. Patents protect scientific principles or the application of scientific principles, inventions. Copyrights protect creative and artistic works, the expression of the artistic and creative expression of ideas. So very different. Both of them are very different. There is an international convention treaty in effect for copyrights. It's referred to as the Berne Convention. Now, the Berne Convention is great. Basically, if you file for a copyright, say in the United States, if you have a copyright in the United States, you have a copyright in all signatory countries to the extent of those countries' laws. So, for instance, if you do have a copyright in the United States, and you believe that someone in Britain, Great Britain, is infringing upon your copyright, you can go to Great Britain and sue them for copyright infringement. You have a valid copyright in Great Britain. Great Britain is a signatory to the Berne Convention, as are a great number of countries. So there is a treaty in effect. And actually, just as an aside, I did mention before, you do not have to register your copyright for it to be effective. But when you register that copyright with the U.S. Copyright Office and they give you that piece of paper, that is powerful evidence. That piece of paper is recognized in virtually every court around the world that you have a valid copyright. It also makes it easier to prove copyright infringement. Why? Well, to prove copyright infringement, you have to establish, one, you have a valid copyright, and two, that it was infringed. And we'll talk about that shortly. With that piece of paper, you automatically prove, number one, you have a valid copyright. If you don't have that piece of paper, you have to prove all the stuff we discussed before, that the work was reduced to a tangible form, that it's completely original as to you, and that's not necessarily an easy thing to do. Okay? The other part of copyright infringement that we should discuss is what is the standard of copyright infringement. It doesn't have to be verbatim. It doesn't have to be identical. It just has to be substantial and material. And I'm going to link up a couple of songs off of YouTube. A big copyright case involved George Harrison from the Beatles, his solo work, his solo song, My Sweet Lord, and the Chiffons, the girl Motown group from the 60s, and their song, He's So Fine. The Chiffons sued George Harrison, claiming copyright infringement, that his song, My Sweet Lord, borrowed or took a substantial and material part from the Chiffons song. So you can listen to yourself and make a determination. But keep in mind, the Chiffons won. They won. And with that in mind, I might hook up another video, mashup video involving Madonna and Lady Gaga. You know, Lady Gaga is certainly a Madonna fan, to say the least, and maybe even a Madonna imitator. You know, the two songs I'll probably put up. One Express Yourself by Madonna, and 2, Born This Way by Lady Gaga. You can listen to those songs and maybe you'll come up with your own conclusions of whether or not Lady Gaga has committed some kind of copyright infringement. All right, that's it for this one. Next lecture, next video, we're going to discuss trademarks and also trade secrets. Okay, very good. Keep up the good work.